that date, my lord, your lordships can consider skipping. Then 3rd July 47, Sardar Patel wrote to Hari Singh stating that interest of Kashmir lie in joining the Indian Union and its constituent assembly without any delay, and also say that its past history and tradition demands it, and all India looks up to you and expects you to take this decision. At this juncture, India was not contiguous whole, and princely states were scattered across the length and breadth of the territory of the country. Then 5th July 47, department as the State Department was a part of the Ministry of Home Affairs headed by Sri Sardar Patel, came into being, and Sardar Patel issued a statement as under. But please see, my lord, page, my lord, 16, your lordships can directly come to, and only the highlighted part, my lord, so that I'm not, my lord, investing your lordship's time more. I have few words to say, my lord, your lordships have. See, my lord, we have dealt with every princely state in a democratic manner, and everyone has voluntarily come, including Jammu and Kashmir, as I will show, my lord, further. I have a few words to say to the rulers of Indian states, amongst whom I am happy to count many as my personal friends. It is the lesson of history that it was owing to her political fragmented condition and our inability to make a united stand that India succumbed to successive waves of invaders. Our mutual conflicts and interns, quarrels and jealousies have in past been the cause of our downfall and our falling victims of foreign domination a number of times. We cannot afford to fall into those errors or traps again. We are on the threshold of independence. Then, my lord, again the highlighted part. But there can be no question that despite this separation, a fundamental homogeneous culture and sentiment reinforced by compulsive logic of mutual interest would continue to govern us. Much more would this be the case with the vast majority of states which, owing to their geographical contiguity and indissoluble ties, economic, cultural and political, must continue to maintain relations of mutual friendship and cooperation with the rest of India. Lord, please, my lord, come to next page, my lord, 17, highlighted and bold part. Lord, I am skipping something which is in the same breath, my lord, same line the Lord Sardar Patel says. Nor would it be a policy, my lord, I am reading the highlighted part only. Nor would it be my policy to conduct the relations of the new department with the states in any manner which severs of the domination of one over the other. If there would be any domination, it would be that of our mutual interest and welfare. My lord, this is where, my lord, Sardar Patel showed the seeds of, my lord, federalism and balance of powers. That nobody would be dominant, nobody would be subservient. The only thing dominant would be our mutual interest and unification and unity of the nation. Then, my lord, 5th July 47, the Union Powers Committee submitted its second report, my lord, which was placed by my learned senior, my lord, Mr. Sibal. Kindly, my lord, first was not placed, and I want to read fully, my lord, only a part was read, and it may have, my lord, potential to assist your lordships. Only highlighted part, my lord. Or I may read, my lord, the full. Momentous changes have since occurred. Some parts of the country are seceding to form a separate state, and the plan put forward in the statement of 16th May, on the basis of which the committee was working, is in many essentials no longer operating. In particular, we are not now bound by the limitations on the scope of union powers. The first point accordingly that we considered was whether in the changed circumstances the scope of these powers should be widened. We had no difficulty in coming to a conclusion on this point. The severe limitation on the scope of central authority in the cabinet missions plan was a compromise accepted by the assembly much, we think, against its judgment of the administrative needs of the country in order to accommodate the Muslim League. Now that partition is a settled fact, we are unanimously of the view that it would be injurious to the interest of the country to provide for a weak central authority which would be incapable of ensuring peace, of coordinating vital matters of common concern, and speaking effectively for the whole country in the international sphere. At the same time, we are quite clear in our minds that there are many matters in which authority must lie solely with the units. My lord, stronger center, but federal structure. My lord, therefore, we say it's more unitary than federal or more federal than unitary. My lord, that is the first rule. Units, and that to frame a constitution on the basis of a unitary state would be a retrograde step, both politically and administratively. We have accordingly come to the conclusion, a conclusion which was also reached by the Union Constitution Committee, that soundest framework for our constitution is a federation with a strong center. In the matter of distributing powers between the center and the units, we think that most satisfactory arrangement is to draw three exhaustive lists on the lines followed in the Government of India Act 1935, that is, federal, provincial, and concurrent. My lord, appendix to this report, my lord, please see the note. The appendix to this report had a union list with a wide array of subjects, that is 87 in total, my lord. Now we have 97, my lord. Now, my lord, kindly come to, my lord, the next date, 10th July 1947. So this is a very important statement made on the floor of British Parliament by Clement Attlee, the then Prime Minister of India. This is not available otherwise, but in one of the recent judgments of the British court, where, my lord, there was a dispute regarding properties of Hyderabad's Nizam. Lord, this is quoted. He had transferred some $1 million and there was some dispute between High Commission and Nizam. That's not relevant. From there, my lord, this quotation, my lord. My lord, at the foot, my lord, I have underlined. I'll read only that part. A feature running through all our relations with the states has been that the Crown has conducted their foreign relations. They have received no international recognition independent of India as a whole. With the ending of the treaties and agreements, the states regain their independence. They had treaties with British government with regard to communication in terms of postal, railways, etc. Everything was come to an end. But they are part of geographical India, and their rulers and peoples are imbued with a patriotism no less great than that of their fellow Indians in British India. It would, I think, be unfortunate if, owing to the formal severance of their paramountcy relations with the Crown, they were to become islands cut off from the rest of India. The termination of their existing relationship with the Crown need have no such consequences. Underline, it is hope of His Majesty's government that all states will, in due course and their appropriate place within one or other of the new dominions within the British Commonwealth, but until the Constitution, etc., I can skip that. The position was clear that princely state became independent technically, but not viable independent units. Lord, may I start at
So sorry, I was with the advocates on record. They have some practical issues about filing, office. So I just with them and it took time. Our own members of the bar who have some, they are responsible to the clients. Yeah. Of course.
I was on page 21. I can, my lord, again reiterate my assurance. Yeah. Whatever may not be necessary for your lordship's perusal, I am skipping it. Why keeping it there, my lord? But page 21, 1947. This would be, my lord, another landmark. Therefore, I must, my lord, bring to your lordship's notice. Under section 9 of the Indian Independence Act, the Governor General of India issued India within bracket Provincial Constitution bracket over Order 1947. What I have quoted is section 6. Section 5 I have not quoted. I just paraphrase it. It merely defined the territories and included within it the exceeding states also. Exceeding states. Your lordships can, my lord, have a note.
Page?
Volume 12, my lord. Document volume 12. PDF page 103.
PDF page 21, I think.
I'm sorry, your lordships are asking about the page of the note?
Yes. Page of the note, page 20 or 28?
21, I'm sorry. Page 20, my apologies. I thought your lordships are on the line.
Yes.
But section 5, my lord, I am on 1947. That is the date, your lordship. My lord Justice calling this is the way it is. Under section 9 of the Indian Independence Act 1947, the Governor General of India.
So 1 second.
No, I'm sorry, my lord. My note. My apologies, my lord. I should have been clear. My note, which your lordships would find respondents' conjoint written submissions. Volume 3. Please, sir. But there were two sections incorporated. Section 5 I have not quoted. I just paraphrase it. It defined territories and included within the term territories exceeding states also. That's all. The lordships would like to note the page number and it's document volume 12, page 103. Now, my lord, the system of accession of Indian states. That was section 6 of this order of 1947. Please see, my lord, 1. May I, my lords? An Indian state shall be deemed to have acceded to the dominion if the Governor General has signified his acceptance of an instrument of accession executed by the ruler thereof, whereby the ruler on behalf of the state declares that he accedes to the dominion with the intent that the Governor General, the Dominion Legislature, the Federal Court and any other Dominion authority established for the purposes of Dominion shall, by virtue of his instrument of accession, but subject always to the terms thereof. Please mark this, Mother, that's the case of the other side, Mother. Therefore, I must bring it to your lordship's notice. And for the purposes only of the Dominion, exercise in relation to the state such functions as may be vested in them by order under this Act, and assume the obligation of ensuring that effect is given within the state to the provisions of this Act so far as they are applicable therein by virtue of the instrument of accession. Now, two, this is important and this was common, my lord, obviously for all who wanted to exceed or have exceeded. An instrument of accession shall specify the matters which the rulers accepts as matters with respect to which the Dominion legislature may make laws for the state, and the limitation, it should be the limitation, there is
The
a
limitation.
and the limitations, if any, so which the power of the Dominion legislature to make laws for the state and exercise of the executive authority of the Dominion in the state are respectively to be subject. But this is my submission and my reading, but an attempt to ensure that unification becomes as difficult as possible because everyone were permitted to put their own terms and conditions. That if you are a princely state, you can exceed, but subject to the terms and conditions. And see how beautifully the founding fathers of our constitution, my lord, dealt with that situation, unified the nation, and the ultimate result was Article 1.
Actually, this was intended to create a sense of confidence in the princely states.
You are not losing everything.
You are acceding to the union, but we are giving you the ability to have reservations in your instrument of accession, by virtue of which you will retain certain subjects to yourself, or you will accept the jurisdiction of the federal legislature, the Dominion legislature, subject to some restrictions which you can yourself impose. So that
you have that option.
we must also put ourselves at that point of time. The Union of India wanted these princely states to come into the fold. But at the same time, we gave them that assurance that you can today decide that you will give only certain subjects to the Dominion legislature.
That can be, my lord, I think, a better way of reading it. And that's why, my lord, Sardar Patel says that the basic theme, the underlining theme would be mutual interest and welfare.
Just as an aside, these instruments of accession, the draft, was there a model draft?
Yes, that is coming.
That was prepared by the Department of States, or who prepared that draft?
That is next day.
All right.
That is next day. And that was common for all. Not the subsection 3, my lord, learned AG, my lord, is guiding me to, my lord.
The variation of the instrument by a supplementary.
By a supplementary instrument executed by him and accepted by the governor, vary the instrument of accession of his state by extending the functions which, by virtue of that instrument, are exercisable by any dominion. So he can forego, he can kind of waive, or he can permit the dominion to do that. Then Lord Mountbatten, speaking to the Chamber of Princes as Crown Representative on 25th July, negotiating committee constituted of 10 rulers and 12 ministers of princely states. This apparatus had in fact been decided upon after heated political debate. Full statement at so and so. I am not reading it, but note, in this process, a model draft of instrument of accession was made. This draft is signed by all princely states of Jammu, and Jammu and Kashmir has not signed any instrument of accession, either special or having any different version at this stage. Now, my lord, India attained independence. So, your lordship would like to see the draft, my lord? That would be.
No, that's okay. That's all right. It's not. We need not break the flow.
Page 23. After 15th August 1947, after independence, Lord Ismay, on the recommendation of Lord Mountbatten, went to Maharaja of Kashmir to persuade him to choose one of the dominions. Then 27 September 47, Nehru wrote to Sardar Patel claiming that the Pakistani strategy is to infiltrate Kashmir now and to take some big action as soon as Kashmir is more or less isolated because of coming winter.
Nehru had anticipated.
And these words proved to be prophetic. This, in fact, happened, and as my lord, it is pointed out subsequently. Then my lord, Pakistan continued hit and run border raids in Kashmir. Then 2nd October 47, Sardar Patel writes to Hari Singh stating that Sheikh Abdullah will be coming to Delhi shortly and we shall endeavor to reach a sensible solution to the difficulties you have from that quarter. So that is the quarter means the Sheikh. That you have some problem which are flagged by Sheikh Abdullah ji, so we will sort it out. Then your lordships would find 15/10/1947, Meherchand Mahajan, Lord, he was the Prime Minister of the then Kashmir, and Lord, incidentally, Lord, he became Lord, a judge of federal court and Lord, eventually Lord, sat in this court Lord, as a Chief Justice of India. Complained to the British Prime Minister that government of Pakistan had broken the standstill agreement, which was between Kashmir and Pakistan. And the whole of state border from Gurdaspur to Gilgit was threatened with invasion, which had already begun in Punj. Then government of Jammu and Kashmir sent a protest letter to the Governor General and the Prime Minister of Pakistan against breaches of the standstill agreement and the continuous raids. Then, my lord, your lordships can skip this. In the autobiography of Justice Mahajan, Lord, this incident is narrated that when he was traveling along with the Maharaja of Kashmir, how his life and the life of the king was saved, my lord, by a sheer coincidence of an intuition of the king that instead of this guest house, we may better stay in some other guest house. So that's all, bro. Then your lordships may kindly see 22nd October 1947. All-out invasion of Jammu and Kashmir started, consisting allegedly of local tribesmen. The other side also, my lord, repeatedly said that there were tribe leaders who were conducting raids. I'll point out the contemporaneous letter written by the king to the government of India. And my lord, Sri V.P. Menon. The raiders destroyed the Uri Bridge and captured Mahura powerhouse, which supplied electricity to Srinagar, which plunged Srinagar into darkness. It was announced that they would reach Srinagar within 2 days. Then 24th October 47, Government of India received a request for help from Maharaja. Then 25th of October 47, the meeting of Defence Committee was held, presided over by Lord Mountbatten, wherein it was decided that the Home Secretary V.P. Menon should fly to Srinagar immediately to study the situation on ground and report the same to the Government of India. V.P. Menon landed in Srinagar and found the entire city, into inverted comma, I quote, oppressed by the stillness as the graveyard all around, unquote. Sri Menon met the PM of Jammu and Kashmir, Sri Meherchand Mahajan, who appraised Sri Menon to the perilous situation and pleaded the Government of India to come to the rescue of the state. Then 26th October 47, the next morning Sri Mahajan called Sri Menon that there were rumors that raiders had reached Srinagar. Sri Menon and Sri Mahajan flew back to Delhi. Sri Menon went straight to the meeting of the Defence Committee and reported the impressions of the situation and pointed out the supreme necessity of saving Jammu and Kashmir. It was pointed out by Lord Mountbatten that till the time Jammu and Kashmir does not accede to India, it would be improper to move Indian troops, and accession would be the only basis which would rightfully give the right to Indian forces to retaliate against the invasion of Kashmir. After the meeting of the Defence Committee, Sri Menon and Sri Mahajan flew to Jammu and woke up the Maharaja and informed him of the developments that had taken place in the Defence Committee meeting. Maharaja desired to accede, reiterated his request for military help, and further informed his intention to set up an interim responsible government. Then your lordships may kindly come to this letter sent by, contemporaneous letter sent by the king, to Sri Menon, that is volume 1, document volume 1, page 7. This would be, relevant for your lordship's assistance. What were, my lord, I'm sorry. Document volume 1, PDF 7.
We've actually read this letter where the Maharaja says that, he had not decided whether to be independent or join the
That was
Dominion.
the only part which was read, my lord. I would like your lordships to read, my lord, at page 8, 2 paragraphs, my lord, which were, my lord, not.
Yeah, he refers to the mass infiltration and other things.
So kindly see the first. The mass infiltration tribesmen drawn from the distant areas of northwest frontier coming regularly in motor trucks using Manshera Muzaffarabad road and fully armed with up-to-date weapons cannot possibly be done without the knowing of the provincial government of Northwest Frontier Province and the government of Pakistan. In spite of repeated requests made by my government, no attempts have been made to check these raiders or stop them from coming to my state. The Pakistan radio even put out a story that a provisional government has been set up in Kashmir. The people of my state, both the Muslims generally, have taken no part at all. With the conditions obtaining at present in my state and to great emergency of the situation as it exists, I have no option but to ask for help from the Indian Dominion. Naturally, they cannot send the help asked for by me without my state acceding to the Dominion of India. I have accordingly decided to do so, and I attach the instrument of accession for acceptance by your government. The other alternative is to leave my state and my people to freebooters. On this basis, no civilized government can exist or be maintained. The alternative I will never allow to happen as long as I am the ruler of the state and I have life to defend my country.
So this letter is taken by Mr. Menon to Sardar Patel, and the Maharaja said that he had instructed his ADC that if Menon comes back, well and good. That means, everything is according to plan. Otherwise, he said, shoot me when he told his ADC to shoot him dead when he's asleep, he said. He said, if he comes back, don't wake him up.
Don't wake me up. Otherwise, if he doesn't, then shoot me, because I would not like to be shot by the enemy forces. That was that's how, my lord, I'm beautifully sent later, my lord. So long as there is a life in me, I'll defend my people. Now, my lord, I am coming back to page 26, my lord.
Yes, now.
The second, Lord, this is accepted. The instrument of accession is accepted. Then 27th October 1947. Your lordships have page 27.
Yes.
Second date, 27 October 47. A Herculean airlift operation of Indian troops was carried out in order to carry out the rescue operations in Jammu and Kashmir, which we continued till 2019. Now it has stopped. Possibly the only provision which is not only mentioned to be temporary, but has been understood by all subsequent parliament to be temporary, has managed to continue for 75 years. The moment Jinnah heard that India has accepted Jammu and Kashmir accession and Indian troops had been airdropped into Kashmir, he gave orders to General Gracie, acting Commander-in-Chief in Pakistan Army. General Gracie represented his inability to issue any instruction without approval of the Supreme Commander. Field Marshal so-and-so informed Jinnah that considering the fact that Jammu and Kashmir had signed an instrument of accession, it would not be possible for British officers serving in Pakistani army to enter Jammu and Kashmir. Thereafter, Jinnah invited Nehru to Lahore to discuss the Kashmir problem. Lord, now how, Lord, this is averted. Lord, the diplomacy at its best. Mountbatten was eager to accept the invitation and Nehru was inclined to agree with Mountbatten. However, Sardar Patel was strongly opposed to the proposition on the ground that Pakistan was the aggressor in this case and India ought not to follow the policy of appeasing the aggressor. As there was a difference of opinion between Nehru and Patel, the matter was referred to Gandhiji. Gandhiji called Nehru, Sardar Patel and Sri Menon to Birla House. During the discussion, it was found that Nehru was running a high fever and his going to Lahore was out of question. It was decided that Lord Mountbatten should go alone. V.P. Menon writes this without any value judgment, without giving his personal views or comments, as a fact as it happened.
Sometimes running high fever is also an act of diplomacy.
Yes, it is, and it was in this case. Yes. It was a diplomatic illness and it was required in the interest of the country. Absolutely right. That you should not go. That they are aggressors and we shouldn't be appeasing.
Sorry?
The illness slip which we normally send to the courts.
It was a
Something like that.
not 5 days. That's what my learned friend is trying to.
He was ready to go to Pakistan. The cabinet put its foot down that it can't be that they are aggressor and our prime minister goes crawling to Lahore to meet Jinnah.
So now please see, 16/12/1947, Sardar Patel, I am at page 27, last date on that page. Sardar Patel issued a statement. Public has already received through the press and over the radio a fairly clear and detailed picture of the settlement. Your Lordships can come to only
The highlighted portion actually.
underlined portion. Democratization of the administration, which has long been the keynote of Congress policy towards the state, has become a pressing problem since August 15. The princes themselves have in many cases begun to realize the spirit of times and have been gradually introducing measures in accord with that spirit. The progress has been in some states low, in other it has been swift, but everywhere it has been sure. Your Lordships can thereafter skip the rest. Then last lines on this, provincial administration in this process of unification and amelioration so that they may derive the full benefit of this great achievement. Then, white paper, I have just given the summary. Before the Constitution of India came into force, a Herculean task of unionization and democratization, ensuring local popular government in place of hereditary princes was going on. For the said process, instrument of accession and standstill agreements were signed. Thereafter, the policy was followed which involved merging the smaller states that were not seen by the government of India to be viable administrative units either into neighboring provinces or with other princely states to create a princely union. It was felt that smaller states lacked resources to sustain their economies and support their growing populations, impose tax rules and other restrictions impeding free trade, and without integration, the economies of the states would collapse and anarchy would arise if the princes were unable to provide democracy and govern properly. Note, this was done despite the instrument of accession and despite assurances given by the State Department and Lord Mountbatten during the accession process. There were not promises held out, as in one of the judgments referred to, but that judgment is thereafter reconsidered. I'll come to that. That these promises, after the Constitution of India comes into force, have no meaning. It is the Constitution which is supreme, and the only sovereign is we, the people of India. There is a judgment on that. In December 47, princes from the East India Agency and Chhattisgarh Agency were summoned to an all-night meeting with Menon, where they were persuaded to sign merger agreements integrating their states into Odisha, the central provinces and Bihar. Thereafter, 66 states in Gujarat and Deccan were merged into Bombay, including large states of Kolhapur and Baroda. Other small states were merged into Madras, East Punjab, West Bengal, and United Provinces and Assam. 30 states of former Punjab Hill States Agency, which lay near the international border. Similarly, this continued to happen depending upon the geographical situation, but But I'm not reading the examples, but there is one example, my lord, which is very, very striking example. But there were many of this kind. But out of 506 plus princely states, about 200 plus were only in one region of Gujarat, that is Saurashtra region. They formed United States of Kathiawar. There was a separate country which functioned for some time and thereafter merged. But they signed a treaty of accession. Kindly have a look at the Treaty of Accession, page 30. The revised Treaty of revised Instrument of Accession. The purpose of my showing is this. Like Jammu and Kashmir, every princely state had put their own conditions. But eventually, one of the theory of Act of State and Article 363, that all treaties, etc., get subsumed in one document, namely the Constitution of India. Please see on page 30, the highlighted part, that all subjects except matters relating to taxation. That those princely states said that taxation will be our subject. You will not touch. The Union of India, the Dominion of India will not touch taxation. Please come to page 31. After 3, the proviso. Does my lords get? Page 31. It is a part of this revised Instrument of Accession. Clause 3 proviso. My Lord Justice Suryakanth.
Yes.
Provided that nothing contained in the said list or in any other provision of the Act shall be deemed to empower the Dominion Legislature to impose any tax or duty in the territories of the United States. United States means United States of Saurashtra. Or to prohibit the imposition of any duty or tax by the legislature of the United States in the said territories. Please come to page 32. There are 2 clauses. This is to show every state had put their conditions. 7. Clause 7. This is again part of the revised Instrument of Accession. Nothing in this instrument shall empower the Dominion Legislature to make any law for the United States authorizing the compulsory acquisition of land for any purpose but subject the Dominion for the purpose of a Dominion law which applies in the United States deem it necessary to acquire any land. The Raj Pramukh of the United States shall, at the request and at the expense of Dominion government, acquire the land, or if the land belongs to the United States, transfer it to them on such terms as may be agreed or in default of agreement determined by an arbitrator so and so, so and so. But till the princely state remained, even after independence, they were called Raj Pramukhs. Even after the federal units, namely the states.
Until the 1956 amendment.
56.
When the Raj Pramukhs were abolished and you had the governor.
Became the governors, not the princely state. But 8. Nothing in this instrument shall be deemed to commit the United States in any way to acceptance of any future constitution of India. This is not in Jammu and Kashmir. It is reverse, I'll show. But they say, I am not admitting that I will accept the future constitution of India in any way to acceptance of India or to fetter the discretion of the government of United States to enter into agreements with the government of India under any such future constitution.
The only difference was that this constitutional history led to the ultimate integration in every sense of the other states like Kathiawar, Saurashtra, Baroda. They didn't follow the 370 route because for J&K, the constitution decided to go to 370. The other states, there was no provision like 370. They merged and they were integrated completely. They accepted list 1, they accepted list 3. They accepted the ultimate dominion powers, executive and legislature of the Dominion of India.
I am just showing this with a view to make one point, that a stand which is now being taken and which has been taken, that we had a special feature and therefore we were given a special treatment, and therefore this provision is kind of a privilege given to us which can never be taken away. But I am just trying to show that there were many similarly situated princely states They had also put their conditions, but eventually they subsumed themselves with the Union of India because of the Act of State doctrine and because of Article 363 and Article 1. But I
They came into the Indian Union as a volition.
Correct.
They joined voluntarily. I mean, we take it as voluntarily. It may have been a little bit of persuasion. It may have been whatever. Real politics. Yes,
Acceptations are made.
obviously, no difficulty. And that was probably the genius of Sardar Patel. There's no difficulty. There's no doubt about it. But the fact, however, remains that insofar as J&K is concerned, J&K bucked that trend. J&K went to the 370 route.
Yes, my lord, but why, how, and till what time?
Right.
That will come, my lord, subsequent.
All right.
And that's why, my lord, for me, as I said, my lord, in the outset, connecting the dots would be necessary.
So the limited point which you are making at this stage is that the instruments of accession of various princely states contain certain reservations. Now we have seen in regard to taxation, in regard to land acquisition,
Binding constitution.
not binding themselves to accepting a future constitution. So the IOAs at that point of these states were hedged with various conditions.
This is also.
But that was consistent with Section 6 of the Government of India Act, which was adopted by Section 9 of the Indian Independence Act. We gave this sop to the princely rulers that, look, you come here on your terms. We are not telling you today to come on our terms. You agree to the Indian Union, you make reservations, and we hope that by and by you will accept full integration into the Union, which they did.
Another point why I wish your lordships made aware of this development is there was an argument that instrument of merger was a necessary attribute for a complete integration. Otherwise, we had kind of an internal sovereignty. Your lordships would recall that Jammu and Kashmir never signed instrument of merger. Many states did not sign instrument of merger. From the date on which Constitution of India came into force and Article 1 came into force as an act of the state, they became integral part of Union of India. And how Jammu and Kashmir got separated, my lord, and how it was only for a temporary period, Lord, would succinctly come, Lord, in subsequent.
Interesting, Mr. Solicitor, this Department of States which existed in the Ministry of Home Affairs post 1950, after the Seventh Amendment, right? 1956.
238 was, yes.
So the Department of States must have been abolished post 1956. You will be still having records in the Ministry of Home Affairs?
I'm sorry, my lord, my instructions are not officer sitting, my lord, was the additional secretary in charge of Jammu Kashmir in MHA. He said that department technically still continues.
So Department of State still continues.
Still continues.
Now, do we have, I'm not sure whether this exercise can be done just for, I mean, you don't have to do it by a very detailed document, but just a tabulation. If we can have a list of the states and, we can have, say, Kathiawar, instrument of accession, supplementary instrument of accession, and merger agreement. Which of the states came into the union with a merger agreement? Which of the states had no merger agreement at all and yet joined the union? I don't know whether that now at this point of time that record will be there. If you can try and record, if you can sort of.
Yes. To a large extent, white paper indicates, my lord, what happened.
I don't know if you have that record. I mean, how many out of these 562 who actually joined the Union of India, actually executed merger agreements?
No, what happened?
What I meant was, how many of these states which joined the Union of India did not execute merger agreements? That will be a smaller group probably.
But possibly.
So, which will then perhaps give some support to your argument that the execution of a merger agreement was not quintessential to acceptance of ultimate sovereignty by India. And second, many princely states were subsumed with the Union of India even without a merger agreement. And various states, therefore, were subsumed in the Union of India only with an instrument of accession.
We'll do that exercise. Substantially, everything is there in the white paper. But if there is something else also, my lords,
all 562 states, not India, what happened, no, there were small little principalities, small nawabs. They got into
were-
larger.
We were just, in fact, Brother Suryakant was giving us a little bit of backdrop about Punjab and Himachal.
To integration with larger states, and then the larger one finally signed the instrument of merger.
Right, but we were wondering, was it possible? Because, Mr. Sibal, what we want a little bit of just factual,
I've understood, Malad.
just factual clarity,
To the best.
that they may have were there Indian states. We shouldn't call them princely states, because as Mr. Sibal says, some of the small Nawab, some the princes.
We will have to say princely states, because Indian state would mean those which were
Governors'
under the
provinces.
sovereignty or suzerainty of
British
India. That's how it has
They were the
always been
governor's
like.
provinces.
That's right.
No, but we just want to know this,
We will, Malad, undertake.
to sort of repeat two things. Which were the states which accepted completely to be subsumed within the Union of India without merger agreements, and followed only the IOA course and straight came into the Union of India?
No such instance, but with respect. The white paper which is part of the record. White paper issued by Sardar Patel.
I'll not
Ministry of State.
formulate
It's
it.
a-
I have understood the question. Let me not, Malad.
You know, Mr. Shankana, I just thought since the there is a
Defense list.
since the Department of States,
This-
since the Department of States exists even today, this is something, this will be, they might take a day or 2 days, but they will be able to do
It
it.
would be, Malad, it would be done. That
It's a table here with the states which have not entered into a merger. Helping your point. Actually, if you want a list of states which have
What
not.
is the source? What is the source of your table?
It's from the white paper.
white paper,
White paper.
there are inaccuracies, I'll put it that way.
So there are states which did not accept the merger and yet became a part of the Indian Union.
State of Mysore, state of Mysore, state of Saurashtra pre-independence, Madhya Bharat, Patiala and East Punjab.
This is,
And this is part from the white paper. There is a chart.
we will, Malad, let's not, Malad, deviate from it. I have, Malad, taken the point.
Your point is that there were other states, basically whether it was 2, 3, 4, 5, whatever. There were other states which did not sign the merger agreement. Apart from,
Yes, there was nothing special which is being claimed.
that's your point. I'm just-
And second, that merger was such a sine qua non, without which you can never be an integral part of India, either under Article 1 or otherwise, or your special status must continue. But please, Manoj.
So in other words, Mr. Solicitor, to sort of paraphrase your submission, it's twofold. First, the expression of reservations in the instrument of accession was not unique to the instrument of accession which was executed by Maharaja Hari Singh.
I couldn't put it that way.
To the execution of a merger agreement was not a sine qua non to be absorbed or become a part of the Indian Union. It's a twofold.
Union of India.
We got the point.
So please come to para 30, to page 32 bottom, my notes. Note 1. The assertion of the petitioners that all others signed the instrument of merger except state of Jammu and Kashmir is false. Several states signed revised instruments of accession, including therein different conditions, etc. I have seen. Neither this process of integration, unionization, linear in its legal application, nor assurances or negotiations remained sacrosanct while framing the Constitution of India and making of this great nation as Union of India. There were states which did not sign revised instrument of accession or merger agreement also joined as part of Union of India. The same thing my lords were indicating. As and when such inclusion of the state took, their respect representative kept on being included in the Constituent Assembly and Schedule 1 kept on being amended, adding each state. Once the Constitution of India came into being on 26 January 50, all states mentioned in Schedule 1 being part of Union of India, losing their sovereignty, if any, which was an act of state, and this is how countries are formed. With coming into force of the Constitution of India, only the Constitution remained the supreme document vesting sovereignty in the people of India, and all other documents got subsumed in one sacred document, that is the Constitution of India. Thereafter, no princely state has successfully asserted its claim based upon any previous document, be it instrument of accession, revised instrument of accession, or merger agreements. The princely states also retain their right to not commit to the future constitution. However, the application of Indian constitution through Article 1 was not dependent upon the same. To my lord, your lordship's scan scheme, kindly come to my lord page 34. My learnation want me to read. The instrument of accession had its source in section 5 and 6 of the Government of India Act. I'm sorry, my lord, my learnation is right, I should have. There is no statutory source of merger agreements, and they were only signed in some cases as a result of negotiations between some states and Dominion of India. It seems, but it's more because of binding the princely state not to go back from its word that they were signed. It doesn't have any statutory source like instrument of accession. Then note 34. 4/11/48, the draft constitution was introduced in the Constituent Assembly. Upon its introduction, Dr. Ambedkar gave a speech outlining how, my Lord Justice Gawai was referring to this, outlining how the constitution was meant to function and how governance under the constitution was to be conducted. Notably, Dr. Ambedkar made clear, Lord, please come to Lord, volume CCD 8, I'll read only 2 paragraphs, not the entire speech, because a part was read, part which was not read, my lord, I would wish, my lord, your lordship, attention is invited, was CCD volume 8, PDF page 63 at 75.
Documents volume?
8.
Lord,
Eight.
document volume 8, PDF page at 75. 64 at 70. Starts at 64 at 75. Only one para, which was not read, therefore I am reading it. Because according to me, this is the heart of what Dr. Ambedkar felt.
Single P.
2936.
2936, yes, Lord. Running page 2936. Lord, unnumbered second para. Some critics, your lordships have. Some critics have taken objection to the description of India in Article 1 of the draft constitution as a union of states. It is said that the correct phraseology should be a federation of states. It is true that South Africa, which is a unitary state, is described as a union, but Canada, which is a federation, is also called a union. Thus, the description of India as union, though its constitution is federal, does no violence to usage. But what is important is that the use of the word union is deliberate. I do not know why the word union was used in the Canadian constitution, but I can tell you why the drafting committee has used it. The drafting committee wanted to make it clear that though India was a federation, federation was not the result of an agreement by the states to join in a federation, and that the federation not being the result of an agreement, no state has the right to secede from it. The federation is a union because it is indestructible. Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole. Its people, a single people, living under a single imperium, derived from a single source. This is the heart and soul of Article.
There is also a reference in his speech of 25th of November 1949.
Yes, my last closing.
Last speech. He says that our constitution is unique. It is federal at the same time unitary.
It is, my lord, it will come, my lord, in the chronology.
This speech of Dr. Ambedkar also lays bare the distinction between a constituent assembly and parliament. At bottom of that page.
Yes, but that was read by Mr. Sibal,
Yeah.
Therefore I missed. But I can go to that.
No, that's right.
But Lord, this was not read. So I'm not repeating
Yes,
what was read. Lord.
Absolutely.
That's the
Yes,
intention.
absolutely.
Then your lordships may not come to the date 16th June 1949. Sheikh Abdullah joins the Constituent Assembly alongside three other representatives from the state of Kashmir, namely Mirza Muhammad Afzal Beg, Maulana Muhammad Saeed Masoodi, and Motiram Bagda. Now, my lords, may kindly see the territorial integration. Lord, this is a part of the white paper. Mr. Sibal, my lord, read up to a particular point. I would like your lordships to read further. Therefore, I have quoted in full. Territorial integration. One of the important consequences of the adoption of the new constitution. Does your lordships get, my lord?
Yes, sir.
35, my lord. I am reading. One of the important consequences of the adoption of the new constitution is completion of the process of territorial integration of the states. The states geographically contiguous to the dominion of India as they existed before the Constitution of India became operative could be divided into two main categories. One, the exceeding states, and two, the non-exceeding states. There were only two non-exceeding states, namely Hyderabad and Junagadh. The exceeding states could be subdivided into the following groups. A. States which were not affected by the process of integration and continued as separate units, i.e. Mysore and Jammu and Kashmir. This was read by the Learned Council. B. Union of states. C. Centrally merged states. D. Provincially merged states. And E. Khasi Real Estate Federation. Please read, my lord, further. This, my lord, I think required to be read. Under the new constitution, all the constituent units, this is new constitution, Article 1, Schedule 1. Under the new constitution, all constituent units, both provinces and states, the later term includes non-exceeding states, have to be classified into three classes. That is Part A states, which correspond to the former governance provinces, directly under sovereignty or suzerainty. Part B state, which comprises the unions of states and the states of Hyderabad, Mysore and Jammu and Kashmir. And Part C states, which correspond to the former chief commissioners' provinces, which became UT thereafter. The new constitution effects the territorial integration of states by means of twofold process. Firstly, Article 1 of the Constitution defines the territories of India to include the territories of all the states specified in the first schedule, including Part B states. This is an important departure from the scheme embodied in the Act of 1935, in that while Section 311(1) of that Act defined India to include British India together with all territories of Indian rulers, the Act did not define territories of Indian Federation. Secondly, please note this, Manoj. Secondly, with the inauguration of the new constitution, the merged states have lost all vestige of existence as separate entities. That is, Manoj, first schedule to the constitution. Manoj, thereafter, your lordships can, Manoj, skip. Your lordships may come to, Manoj, 849. But this is how, my lord, you retain your sovereignty. I have given an example. That internal and external sovereignty, my lord, for example, we have a treat. I'm sorry, my lord, I'm sorry, I missed one. July 49, my lord, kindly see, my lord, July 49. Note by the Ministry of States regarding the Indian states, it was specifically noted that Jammu and Kashmir would be treated as a part of Indian territory. Please read only first para. This note was before the Constituent Assembly. We have checked it. The government of India have considered the matter in its various aspects and are of the opinion that in view of the present peculiar situation in respect of Jammu and Kashmir state, it is desirable that the accession of the state should be continued on the existing basis till the state could be brought to the level of other states. Idea was prevailing situation then, not instrument of accession or lack of merger, etc. The prevailing situation then, idea was to bring it at par with other states. And the important part, a special provision has therefore to be made in respect of this state on the basis suggested above as a transitional agreement. arrangement. This was the promise, my lord, by the Constitution Assembly to the nation, that as a transitional arrangement, we are making a provision, a departure from other states. Lord, second, my lord, 8849, your lordships can scale.
No, Mr. Solicitor,
Yes, sir.
you may read little below that also.
Yes.
The Ministry of State
The
suggests.
Ministry of State suggests
Oh, that's
for
very
consideration of the drafting committee the following approach to this question. One, Jammu and Kashmir state may be treated as part of Indian territory and shown in states specified in part 3 of Schedule 1. I am obliged, I am going a little faster.
Go further on.
Yes. A special provision may be made in the Constitution to the effect that until Parliament provides by law that all provisions of the Constitution applicable to the state specified in Part 3 will apply to this state, the power of Parliament to make laws for the state will be limited to the items specified in the schedule to the instrument of accession till Parliament makes the law governing the accession of the state to the dominion of India or to corresponding entries in list 1. Well, this is very important. I missed it, Lord. I am really grateful, Lord. Then, Lord, 8849 is just an example how you retain your sovereignty. That is, my Lord, Bhutan. Bhutan has a treaty with us. Contemporaneously signed, my Lord, in 4750, my Lord, that is 8849, where, my Lord, in external affairs, India has suzerainty. We don't have sovereignty. They are sovereign, but, my Lord, we have the 12-10-49. In a speech to the Constituent Assembly, Sardar Patel stated that although the initial policy of the government was to permit states to have a separate constitutions, this idea had now been dropped as a legacy from the rulers and the polity, and that in a people's polity there was no scope for variegated constitutional patterns. We therefore discussed this matter with the premiers of various unions. Unions means the princely states or association kind of a thing, and decided with their concurrence that the constitution of the state should also form an integral part of the Constitution of India. The natural implication of this statement is twofold: that Article 370 was of a temporary nature, and that it was meant to last only until the disturbed situation in Jammu and Kashmir was normalized. Now, Lord, is interesting. Draft Article 3065. Gopala Swami Iyengar had discussed the position of draft Article 370 in detail with Pandit Nehru before his departure to United States. Lord, generally speaking, when we go through, Lord, Gopala Swami takes the line which Pandit Nehru wants him to take. Lord, and there is some difference of views between Sardar Patel and Nehru on this issue. Principled differences. However, there was strong opposition in the Indian National Congress for giving any special provision. The same has been noted as under in my reminiscences of Sardar Patel by Vishnu Shankar. Lord, Vishnu Shankar was the principal secretary to Sardar. He was secretary within Beckett Kashmir in those days and rose to become the cabinet secretary. Lord, his version is considered to be one of the authentic versions of what transpired during that period. Please read, my Lord, what he says. In the party, there was a strong body of opinion which looked askance at any suggestion of discrimination between Jammu and Kashmir state and other states as members of the future Indian Union, and was not prepared to go beyond certain limits in providing for the special position of Jammu and Kashmir. Sardar was himself fully in accord with this opinion, but due to his usual policy of not standing in the way of Pandit Nehru and Gopala Swami Iyengar, who sorted out problems in their own line, he had kept his own views in the background. In fact, he had not taken any part in framing the draft proposals, with the result that he heard the proposals only when Gopala Swami Iyengar announced them to the Congress party. The announcement was followed by a storm of angry protest from all sides, and Gopala Swami Iyengar found himself a lone defender with Maulana Abul Kalam Azad, an ineffective supporter. Metaphorically, the situation may be succinctly described by saying that both Gopala Swami Iyengar and his proposal were torn to pieces by the party. Now, J&K was included in Part 3 states under Article 1, and its territories were defined as the territory which comprised of the corresponding Indian state immediately before the commencement of the Constitution. Then, my lord, I have given the list, your lordships can skip. Please come to 1510-49. 4 seats were allocated in the Constituent Assembly to Kashmir. The debate is quoted as under. My lord, please come to page 39, somewhere in the after the figures. The foregoing paragraphs have dealt with changes in the numerical strength of the Constituent Assembly and in its representative character. That was, however, a series of changes of a different kind in the representation accorded to the Indian states which deserve separate mention. While the Constituent Assembly was in session holding its deliberations between December 46 and November 49, many of the smaller states were merged in provinces. Many others were united to form Union of States, and some were directly administered by the center as chief commissioners provinces. These changes necessarily called for a readjustment of representation of states from time to time. The general plan adopted was as follows. The states were merged in provinces. The Speaker of the Legislative Assembly of the province was authorized to hold elections and by-elections wherever necessary and notify the person or persons elected or nominated. 2. Where the states were united to form Union of States like United States of Kathiawar, and in case of Hyderabad, Mysore and Jammu and Kashmir, the Raj Pramukh or the ruler of the state was entrusted with this function of selecting, not obviously not electing. And 3, in case of states constituted into chief commissioners provinces, this function was entrusted to the chief commissioners. So far as allocation is concerned. Now kindly come to the next. But this is a very, very important letter, my lord, in my respectful submission and from my perspective. 1610-1949. On the evening of introduction of draft Article 306A, that is erstwhile 370, after Gopala Swami Iyengar shared the draft of the article, Sardar Patel wrote a scathing letter to him, making his position clear as under. My dear Gopala Swami, thank you for your letter dated so and so, which I received only this afternoon on my return from Constituent Assembly. I find there are some substantial changes over the original draft, particularly in regard to applicability of fundamental rights and directive principles of state policy. You can yourself realize the anomaly of the state becoming a part of India and at the same time you can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. And I'll show till 76, Article 21 was not applicable in a truncated way. Article 19, there was a sub-article added as it applied to Jammu and Kashmir, that the reasonable restrictions would be those which will be prescribed by the legislature, meaning thereby the persons against whom citizens invoke Article 19 would decide what would be the reasonable restrictions. I'll come to that. I do not at all like any change after our party has approved of the whole arrangement in presence of Sheikh Sahib himself. Whenever Sheikh Sahib wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government, or even on a personal basis to you and the Prime Minister who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead. Clear. No ambiguity, no. Then, my lord, next date. Then, my lord, Jammu and Kashmir was, my lord, received 4 representatives. Then, my lord, 7. I am on page 14. Yes, 17/10/1949. Draft Article 306A, which is the present Article 370, was debated in the Constituent Assembly. Gopala Swami Iyengar, who was chiefly involved in the drafting of Article 370, gave a speech in which he stated that regard to the accession of the state, that, kindly see, my lord, only the highlighted part, as the House is also aware, not at page 14, as the House is also aware, instrument of accession will be a thing of the past in the new constitution. The states have been integrated with the federal republic in such a manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the republic. Please mark this one. But they are mentioned in the constitution itself, and in case of practically all states other than the state of Jammu and Kashmir, their constitutions also have been embodied in the constitution for the whole of India. All those other states have agreed to integrate themselves in that way and accept the constitution provided. Maulana Hasrat Mohani, why this discrimination, please? Not just pausing here for a minute so that the debate doesn't get boring. Maulana Hasrat Mohani was an eminent Urdu lyricist of his time. And if all of us, most of us have heard, Chupke Chupke Raat Din Aansu Bahana Yaad Hai. That is by Maulana Hasrat Mohani. I don't want to sing it. I know my limitations, and I'll spare all of you on the lightest. Then, my lord, but there are several good lyrics, good Urdu ghazals and nazams written by Maulana Hasrat Mohani. Yes, yes. The question is very important. That why are you discriminating from people of one state and people of other? And your lordships would be shocked when I show the discrimination. We have analyzed, my lord, how the provisions were selectively picked up, modified and applied to one state. And I am not saying that my power is taken away or state's power is taken away. So far, the residents of Jammu and Kashmir were being deprived of what I will show to your lordship. Till 5th of August 2009. The Honorable Sri N. Gopala Swami Iyengar, he replies, the discrimination is due to special conditions of Kashmir. That particular state is not yet ripe for this kind of integration. It is the hope of everyone here that in due course, even Jammu and Kashmir will become ripe for the same sort of integration as has taken place in case of other states. Cheers. At present, it is not possible to achieve that integration. There are various reasons why this is not possible now. I shall refer again to this later. Please note this, my lord. Then, after acceptance of 370, P. Shankar expressed his disappointment at the passing of the special provision. Sardar Patel summoned him to lunch. The description of the same meeting in my Reminiscences of Sardar by Vishnu Shankar is as under. His principal secretary, who was Secretary Jammu and Kashmir and became the Cabinet Secretary. Please note, my lord, read one by one, my lord, beautiful words. As soon as I was seated, Sardar spoke. So you are annoyed with me for having accepted Gopala Swami's formula. I queried that if he felt that way, why did he not indicate his mind earlier? He said, see the maturity of the man and the statesmanship. I was deeply concerned at the situation. Gopala Swami had acted under Panditji's advice. If Jawaharlal were here, we could have had it out of him. But how could I do so with Gopala Swami, who was only acting under orders? If I did, people would have said that I was taking revenge on his confidence when he was away. Gopala Swami had appealed to me for help. How could I have let him down in absence of his chief? Since my Prime Minister is not present, I'll not let him down since my Prime Minister is out of the country. I then asked why he had let down the country and other states whose constituent assemblies had been scrapped in accordance with his advice and policy. He conceded the validity of the criticism but pointed out the delicate international position of the state and the issue of its relationship with India. We felt that the present situation had to be tied over without giving up the eventuality, and this had been done under the formula. Please note this, my lord, this only Sardar could have spoken. And now, my lord, it has proved to be, my lord, prophetic. He said that after all, neither Sheikh Abdullah nor Gopala Swami was permanent. The future would depend on the strength and guts of the Indian government.
This is not a political.
And if we cannot have confidence in our strength, we do not deserve to exist as a nation.
If I may just seek the permission of the London Solicitor General, we were all told on 3rd of July to file all documents.
Again,
Nothing to be filed thereof.
Continuous interest.
This is administration of deeds.
Mr. Sri Singh,
Who were given, all of who were given.
Mr. Singh, let him continue. I mean, what's
this side patient.
Uncomfortable.
When your side argued, there was no interruption from either the attorney or the solicitor.
Lord, many of them provided additional documents,
But,
additional judgments. We never objected.
these are well established. These are well known.
Why such sensitivity over some statement which comes because may not be palatable?
Also, Mr. Singh, equally we know that when we decide the matter, we have to give primary importance to primary sources,
Yes.
such as the statutes, the instruments of accession. These are other documents which he is relying on to the
Nurani
extent.
was dead. Nurani was not even born when all this happened.
It's extract put in a list of dates.
I did object to Nurani. It's a one-sided
No,
picture.
your nodal counsel argued that he received it Sunday evening.
I'm sorry.
Your nodal counsel, he agreed in the morning that he received it long back, but he did not circulate it amongst yours.
On Sunday, last Sunday. man.
I'm saying
Last
that there are extracts from a book in a list of dates. The book is not on record. It's not a document before your lordship.
We'll
It's
give
not
you
a-
copies of the book.
That's not the point. I mean, this can just keep getting enlarged. I'm only saying that let's stick to the record. We were
Lord, if
told-
AG Nurani can be read, even a newspaper can be read. I'm sorry, I'm saying this with seriousness. I have read AG Nurani. It is a one-sided.
Correct.
But we didn't object. my lord.
That's all right, the solicitor. You don't have to go that far.
No, my lord, I'm on page 40.
Mr. Singh, all that this really indicates, it's not like, conclusive evidentiary material.
Yes, my lord.
This is used to demonstrate that there were different points of view, different perspectives which were flowing in at that time.
A historical perspective of what people
perspective.
felt at that particular
There
time.
are several
And
things
in
mentioned
internal
by
dialogue that was
I would-
taking place, where one side was expressing one view, the other side was strongly opposed to it. Ultimately, we have to interpret the provision of the Constitution.
Exactly.
How this all came about,
This
that's
is
all
an
that we are
age
concerned.
of-
Well, you also referred to certain
I
documents.
mind whether this is going on, but I mean,
That's all right. These documents give us some
That's right.
air of the background,
I-
of different perspectives to the
Lord,
background.
several new facts were stated. I didn't object because I didn't want to trivialize the dialogue. This is the constitution bench we are asking.
Etc., please proceed.
So kindly come to page 44.
If I not can be read in this.
Yes, sir. Lord, 43 bottom. In the course of discussions regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also
No, you are reading page?
44.
Page 43, last date, my lord. This is Constituent Assembly debates, CCD, my lord, document volume 8, PDF, my lord. I've quoted for your lordship's easy reference.
just for the back.
In the course of discussion regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also have been brought in on the same level as other states, but unfortunately, much to our dissatisfaction and chagrin, if I may say so, this would not be done. This is a delicate subject and I'll not say anything more on this. But please read this, my lord, now. This is very, very important, and in my respectful submission, the answer, my lord, lies here. what happened to Jammu and Kashmir, its sovereignty, external, internal, my lord, the difficulty is the petitioners are confusing, in my understanding, internal sovereignty with autonomy. External sovereignty, my lord, nobody can dispute that it is with the Union of India. Internal sovereignty in the facts of our case and in the constitutional structure which we have accepted would mean autonomy of the federating units. And which autonomy is there with every state? There are none.
It's actually there with every institution.
Every institution is autonomous. So that's not
I
internal.
mean, we have the autonomous authority to decide a constitutional issue.
Commission.
So we can't say that internal sovereignty vests with us. We are an independent autonomous institution under the
They
constitution.
are confusing the word autonomy with internal sovereignty. There is no internal sovereignty.
Except that, Mr. Solicitor, to paraphrase their argument fairly, what they are saying that, look, we gave up external sovereignty, there's no doubt about it. They say that we have acceded to the Indian Union, that's irrevocable. But they said that the course of events, the adoption of 370, would indicate that while there was a giving up of external sovereignty, a modicum of internal sovereignty, which was exercised by the then Maharaja, that was not ceded to the Indian Union. That seems to be the line of
That's the submission. And my respectful
and
submission.
therefore they are relying on various judgments of our court to indicate Indira Nehru Gandhi versus Rajnayan, to indicate that sovereignty has an external component, it has an internal component also.
Different context, but I'll assist your lordships on that.
By and by, in your turn, you can explain
Yes,
that
yes.
that line of. We are really on the list of dates. You can go ahead. Yes.
25th 11/1949, Yuvraj Karan Singh issued a proclamation for the state of Jammu and Kashmir. I have given the pagination, by which he declared and directed that Constitution of India, shortly to be adopted by the Constituent Assembly of India, govern the constitutional relationship between the state and the contemplated Union of India, and shall be enforced in the state by him, his heirs and successors, in accordance with the tenor of its provisions. The said proclamation is worth quoting in full. Whereas with the inauguration of the new constitution for the whole of India, now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. Your Lordships may kindly recall the instrument of accession was under Government of India Act and subsequently Independence Act. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political and other fields, it is desirable that the constitutional relationship established between this state and the Dominion of India should be continued as between this state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, but please mark this, this is where, my lord, they are highlighting and I will have to meet with, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions. That the provisions of the said constitution shall, as from the date of its commencement, supersede and abrogate all other constitutional provisions inconsistent therewith, which are at present in force. This is beyond any instrument of accession or merger. This is accepting supremacy of our constitution and surrendering the sovereignty to the constitution, where the sovereign is we, the people of India. No.
Of course, when he made this proclamation on 25th of November 1949, this is on the same day as Dr. Ambedkar's last address to the Constituent Assembly, the famous address to the Constituent Assembly. So by this point of time, the entirety of the constitution had been formulated,
including 370
right?
and 1
Including 370.
and Article 1.
Therefore, when he makes this proclamation, he makes this proclamation in the light of 370, which also is before him,
Correct.
right? There can't be any doubt about that.
There cannot be any doubt. I bow down. And he is also very clear that what he is doing, at what stage and under what statute, what constitutional mechanism which is temporarily provided. The said proclamation is not only beyond the instrument of accession, your lordships can skip that, I have orally said. Two, the preamble to this proclamation shows that it was based on the conviction that the best interest of the state required that the constitutional relationship established between the state and to Dominion of India should be continued as between the state and the contemplated Union of India, and it refers to the fact that the Constituent Assembly, which had formed the Constitution of India, included the duly appointed representatives of the state, and that the state constitution provided a suitable basis to continue the constitutional relationship between the state and the contemplated Union of India. At this juncture, the Constituent Assembly of Jammu and Kashmir was not formed. However, it is important to note that the princely state, through its ruler who had the authority to surrender the sovereignty of Jammu and Kashmir to the Union of India and made it specifically enforceable in the state, including Article 1 thereof, could never have thereafter formed a constituent assembly for his state, which would be a plenary constituent assembly, which can create a document having the sanctity and sovereignty of the constitution of a nation in which the state merged. It was merely an act providing for internal governance of the state, which was an integral part of the sovereign, that is Indian dominion. But my respectful submission is that Constituent Assembly of Jammu and Kashmir, which formed subsequently, was not a plenary Constituent Assembly the way we had our Constituent Assembly, because by that time the sovereignty had already merged. There cannot be two constitutions. There cannot be, and therefore, my lord, I am saying that the sanctity of that document, which we call Constitution, is nothing more than an act of legislation, and I will substantiate that. Lord, note 4. This furthers the point that the words Constituent Assembly in Article 370, sub-Article 3, can be read only as Legislative Assembly, even without the aid of Article 367. Apart from this,
Solicitor, this will require a little clarification.
Yes, yes, but
This
when I
will
come-
require a little clarification. At this stage, we are not saying anything because when we talk about Article 370, including the explanation which is added, which
as
is,
separate submissions.
that will require clarification.
But I'm conscious this is not the best point where I can justify the substitution.
We are not stopping you at this stage because you're going on facts.
This is not the best point on which, my lord, I would be able to justify substitution of a defunct Constituent Assembly with legislature. I'm not, my lord, joining issue with it. I have other set of submissions on that. At this stage, my lord, this is the perception, my lord, which I am presenting for your lordship's consideration. Now, my lord, kindly come to 26/11/49. The Constitution of India is adopted. For the rest, I can.
So, Mr. Solicitor, as apropos what fell from Brother Justice Sanjeev Khanna, we are not engaging in a dialogue with you on any of these notes right now, because we take it that you will be arguing these aspects independently later on.
I just want to draw.
So right now we'll run through the list of dates with you, so we have a broad drift of your analysis.
I just want to point out
But
broadly.
we take it that you're going to take up each one of these strands later and argue them independently.
have-
Then we can, so instead of asking you any of our doubts right now, we'll reserve it to when you go into the themes themselves. Right now we can just run through the list of dates.
What I intend
better.
for assisting your lordships, the way is this, my lord. After this, my lord, I'll show how the Constitution, how 370 worked till 2018, and some of the things are really shocking. And my lord, I want your lordships, my lord, to know about, because practically, two constitutional organs, state government and the president, in consultation with each other, can amend any part of the constitution the way they want and apply it to Jammu and Kashmir. For example, I'll elaborate on this. Please mark this. The preamble of Indian Constitution was made applicable to Jammu and Kashmir by way of a constitution order under Article 371D in 1954. Thereafter, in 42nd and 44th Amendment, the word socialist and secular came to be added. That was not made applicable till 5th of August 2019. Jammu and Kashmir Constitution was not having either the term socialist or secular. And I will show my lord, the devastating effect it would have, my lord, if this constitution, which according to me is nothing more than a legislature, would not have been repealed the way, my lord, we have done. I'll explain the procedure which we have followed. I must satisfy your lordship's conscience. My lord, your lordships have very rightly flagged that ends may not justify the means, but I'll justify the means also. They are constitutionally permissible means.
Eventually, when you argue that this is really not a constituent assembly but a legislative assembly in its original form, you'll have to answer how this squares up with clause 2 of Article 370, which specifically says the constituent assembly formed for the purpose of framing the constitution of that state.
Correct. I have to answer.
That is because there's a textual answer which may militate against your line of approach on that.
Yes.
Anyway, we'll discuss that later on because.
Kindly come to my lord, page 47. So it's, can I, my lord, this is a new point, my lord. Now, first constitution order comes, my lord, I
think we can continue on
Monday
morning.
Since your lordships is hearing this matter on Monday, we had some commitments. Your lordships will pardon me for some.
Certainly,
not to be there,
of course.
But I didn't know about this.
Monday running around in
No.
miscellaneous matters.
He can't.
Never.
He can't.
Never, my lord. I am before the constitution.
Yes.
No way in the world.
Out of question, my lord. I would not make any question. Would like to.